This is the employment law video presentation, video lecture. The main thing about this lecture will be, it will be more of a shotgun where we talk about the employment at will doctrine briefly and various statutory protections of workers. We will leave the labor law portion for another lecture, and if time permits, we will go into a deep lecture on sex discrimination, which will include sexual harassment and pregnancy discrimination. I apologize for the voice. We'll try to get through this. You may have been told about the employment at will doctrine in your ethics class if you've taken it. Certainly if you've taken an undergraduate B-Law course, you learned about it. Most of you probably just have heard about it in your business practices. But the notion generally is, as it grew up in the common law, is that under the employment at will doctrine, an employer can terminate a worker with or without cause, and with or without notice, and the employee can leave employment with or without notice. As the Tennessee courts have said, an employee can be terminated for good cause, bad cause, or no cause at all. As I said, it grew up in the common law. But all states recognize exceptions. Some states don't recognize it at all. In fact, as the number of states not recognizing it has grown over the years. But these three exceptions, two of which all states recognize, and one only a minority of the states recognize, are one, the public policy exception, the implicit contract doctrine, and where the minority of the states follow the covenant of good faith and fair dealing. I believe California is one of those states that follow that one. The public policy exceptions are such that they can be statutory or non-statutory. For example, some specific statutes limit the power to terminate. For example, filing a workers' compensation claim or filing a complaint or under Sarbanes-Oxley or securities regulations or other statutory provisions like the Clean Air Act and so forth. We want to encourage whistleblowing, and whistleblowing is a large exception. You can also say the same thing about Dodd-Frank. The financial reform legislation includes it as well. You can also have public policy exceptions that just simply grow up out of ethics. For example, you cannot hire a person, an employee, with the provision that that employee will never file a workers' compensation action against him, or if that worker will never attempt to join a union or form a union. Those would be public policy exceptions. The implicit contract doctrine, this is one that an employer can protect itself against. An implicit contract is one that is not founded in fact, but is founded in law. Let me rephrase that. It can be founded in fact, but just not expressly. And the fact is, that's a better way of looking at it. Usually we have two types of contracts outside of the quasi-contract situation. And these are express contracts, implied contracts, and quasi-contracts. We can ignore the quasi-contracts. The express contract is clear. It's a written employment contract, or it's a verbal employment contract, but the terms of the agreement are spelled out. In the implicit contract, that's one in which the facts indicate that a contract is existing. The most common way that this is done is in an employee handbook. If the employee handbook lists the ways that an employee can be terminated, if you do items A through L in the employee handbook, inebriation, drug use, dishonesty, incompetence, things of these nature. If the employee handbook also says that you're going to have continuous employment throughout your tenure, as long as you abide by the employee handbook, then that will create an implicit contract between the employer and the employee. The good thing to do to prevent this is to make sure that you don't offer this continuous employment, and you include a notice provision in the employee handbook, usually requiring a signature understanding to signify that they understand it, and that is the employer and the employee expressly understand and agree that this employee handbook does not create an express or implied contract, and that the employee can be terminated at will. The covenant of good faith and fair dealing is simple. In essence, it's an implied covenant that the employer will not terminate a worker in bad faith or without dealing fairly. For example, if the employer has an employee who has worked a long time on a particular contract in order to get a large commission, and the work is almost done, if there's going to be a cutback in the sales people, then the employer cannot target that particular employee, that particular salesperson, for termination simply to save the commission. Let's look at the major legislation within employment law. As I said, labor law will be dealt with at another lecture. This is not exclusive. It certainly doesn't cover state law because you have parallel laws within the state, but it's the most significant in total. The Civil Rights Act of 1964, Title VII, prohibits discrimination in employment where there are 15 or more employees. This covers race, color, religion, national origin, and sex. Sex does not mean sexual preference or sexual orientation. More about that later. ERISA, the Employment Retirement Income Security Act, has been around for 40 or 50 years. This is in the area of pensions, retirement plans, and employee benefit plans. It requires a degree of fairness. It requires a degree of notice. It requires a degree of protection of survivors, surviving spouses. Surviving spouses have interest in pension and retirement plans, for example. They have notice provisions, and they have a right to agree to any distributions out of retirement plans. ERISA also protects rank and file employees because it creates a fairness. An employer cannot have a qualified plan if the employer's intent by facts and circumstances are that the employer is trying to give all of the benefit to key or top level employees. This is something that came out in the early 90s. One that everyone is familiar with is Social Security, and that's composed of two elements: the Old Age Survivors Insurance and Medicare. These are taxes. These are employment taxes half of it paid by the employer, half of it paid by the employee. Younger workers need to understand the significance of the Old Age Survivors Insurance Act. If you're young, you may never see Social Security. That's simply a fact. That's a physical possibility, maybe even a probability. Simply the government funds will simply not last. There are not enough workers. But one of the benefits of the Old Age Survivors Insurance Act, i.e. Social Security, is that it has a disability provision. And that disability insurance may have more value when you're younger. When you're younger, there is a greater risk of disability. Workers' Compensation Act, this is state law. Every state follows it. It's similar. Workers' compensation is provided by insurance paid by the employer, solely by the employer. And workers who suffer an injury that arise out of and in the course of employment. The injury arises out of and in the course of employment have a compensable injury. And workers' compensation will pay medical out-of-pocket expenses, pay for some lost wages, and pay for some dismemberment or permanent loss, like a finger or an arm or a leg or ear or some eye or something of this nature. It does not pay what an individual would get in a lawsuit for negligence, but it's no fault. It is a no-fault insurance for the employee. Workers' compensation carries with it an exclusive remedy doctrine. The exclusive remedy doctrine says that an employee who suffers an injury that's covered under workers' compensation, the workers' compensation provides the exclusive remedy to the employee. The employee cannot sue the employer or a coworker. As we learned in product liability, in the Van Campanoli versus Camco industry case, the injured worker can maintain a lawsuit against a third party for negligence or under product liability. Unemployment insurance has two elements to it: state unemployment tax and a federal unemployment tax. It's generally handled by the state, and the amount of the unemployment tax depends on the history of the industry for the number of persons who are laid off from employment, terminated without cause. It is not a fully inclusive of the loss of the income. It simply is more of a substance, subsistence type income rather. COBRA, most people don't know what the specific name of this law is, but we understand what COBRA is. COBRA came about in, I think, 1986 under the Comprehensive Omnibus Budget Reconciliation Act. It's an end-of-the-year budget provision, kind of a tack-on. Excuse me. What COBRA does is COBRA started a shift of social responsibility from and fiscal responsibility from the government to the employers, where the employer has to bear more of the social cost. COBRA was extremely important leading up to the Affordable Care Act, because now the Affordable Care Act has a provision that of no pre-existing conditions on new insurance policies. Well, that was the case back in the 1980s and the 90s and the first decade of this century. Insurance policies typically had pre-existing conditions, meaning the employee would not be eligible, or the insured would not be eligible for coverage until a certain amount of time after obtaining the insurance policy. COBRA provided for a right of an employee who terminates his or her employment, or whose family member has insurance coverage under a group policy terminated. For example, a divorce, or a child goes off to college. They would be able to continue their group coverage at the employee's sole expense. Well, you can see that if an individual had a pre-existing condition, a heart condition, diabetes, or some other medical condition, they couldn't afford to take another policy elsewhere because of the pre-existing condition. So to have their medical expenses covered, they would rely on COBRA. And the group insurance policy premiums under COBRA was much less than paying out-of-pocket expenses for medical services. Continuing on with this move toward pushing the social cost over to employers away from the government was HIPAA, the Health Insurance Portability and Accountability Act. There's two provisions here. One, on the accountability side, that's the privacy element. I really disagree with this part from a policy standpoint and a practice standpoint. I think it's substantially added to the burden of healthcare providers and does more limitations on good healthcare than it helps. The portability side. Again, before the Affordable Care Act, we ran into the problem, as I talked about in COBRA, of pre-existing conditions. Under HIPAA, which is a President Clinton piece of legislation, an employee who was covered for a year, or had been covered for a year under his or her group health insurance policy with their employer, was and who took employment elsewhere where there was a group health insurance policy, then that employee would be entitled to immediate protection under the new employer's group health insurance without any pre-existing condition limitation. The accountability side, as I said, is the privacy side. It was originally, I think, targeted for the evils of what the health insurance industry would do in terms of sharing information, personal information or health information about employees or about the insured, the clients. But HIPAA expanded the privacy, not only protecting against what the health insurance companies were doing, but also limiting the ability to give out information by healthcare providers. This is why you see secretaries on the floors at hospitals are not working with their computers in view of the visitors who come to the floor and to the desk, asking about patients. They in essence have to shield the medical records or what's being input on the computer about patients. They have to shield that from view of anybody who does not have a need to know. The Age Discrimination in Employment Act. This piece of federal legislation protects workers 40 years of age or over against discrimination in employment. It contains provisions similar to other statutory protections. It prohibits harassment based on age. It prohibits discrimination in hiring and firing and promotion and transfer, etc. The Americans with Disabilities Act. We're going to have more on this one and the next one. The ADAAA Amendments Act of 2008. We'll talk a bit more on those, but just keep in mind that these two, as with the Federal Vocational Rehabilitation Act, protect workers who have disabilities. That's a physical or mental impairment that limits one or more major life activities. The ADA covers not only employment of 15 or more employees, but also covers public accommodation as well. Much like the Civil Rights Act of 1964 did when we talked about Heart of Atlanta Motel and Katzenbach versus McClung, the discrimination in public matters. Fair Labor Standards Act. This is one of the oldest of the federal protections. The Fair Labor Standards Act had three broad provisions to it: child labor, minimum wage, and overtime pay, the wage and hour law. Child labor puts age limitations on working. As a general provision, no child under the legal age of majority, i.e. no child under the age of 18 can work in a hazardous environment, except, of course, on the family farm, which is probably one of the most dangerous places. But that's simply a risk of farm life. Small children can do little things like assisting with the family business, like sweeping the floors for a store, or child actor, and then maybe delivery of newspapers. And then the 14 and 15-year-old bunch can work part-time. They can't work during school hours. They can't work at night. The 16-year-olds can work some at night, but not during the school hours. The 17-year-old can work at night and during the school hours if in a cooperative type program, or whenever they don't have classes or they are not required to be in school. And then, of course, at 18, you're free. The child is free at that point because it's no longer a child. The minimum wage, right presently set at $7.25. This is the federal minimum wage. There had been discussions about increasing it. There are always discussions about increasing the federal minimum wage. States are not limited by this. A state can have a higher minimum wage. A locality can have a higher minimum wage. And the fact is, that in Los Angeles and Seattle, they've established a $15 minimum wage. It seems to be the movement. I would ask you this as a matter of policy. How can you have a high minimum wage if you have an unlimited supply of the labor working at the minimum wage? This is part of the immigration policy. You can't have one and maintain the other. It makes no sense. It creates an inefficiency. Another thing that I would add on this is that whenever the government establishes a minimum wage, the minimum wage provides the basis upon which all other employees are paid. If an employee is entitled to a $15 minimum wage by working at a fast food place, why would that individual go to college to work as an elementary school teacher for $30,000 or $35,000? Doesn't make a lot of sense, does it? And if the $15 an hour worker who works fries or works the counter at a McDonald's or a Wendy's, what does the assistant manager make? Or the person who has been there for 2 years working the cash register? Everything is built off of it. In essence, there is an escalator in the cost. The issue is not how many people presently make the minimum wage. The issue is what is going to be the total economic effect. It'll have some inflationary effect. It'll also have some, as a matter of policy, over the high costs. What do you do about the high cost of labor? If you can substitute machine for manual labor, then you will do that. The third provision of the Fair Labor Standards Act is the overtime provision. Non-exempt employees, usually these are non-salaried, non-supervisory people, are entitled to a premium on their labor of 1.5 times the base salary for any hours worked over 40 hours for the week. Special provision under the Fair Labor Standards Act for healthcare workers and government. Family and Medical Leave Act. To me, this is probably the best piece of legislation that came out of the Clinton administration. Covered employees have a right to take unpaid leave for serious illness or injury to themselves or to an immediate family member, and for pregnancy or adoption or taking in a new foster child. The employee must work at an employer of having 50 or more employees. It's kind of a middle-sized company. And the employee must have worked for the year, for 12 months, for the whole year, immediately before the filing the claim for FMLA leave. It's been targeted. The Democrats would certainly like to see pay for this. It would be expensive, and the question is, who would pay for it? GINA, the Genetic Information Disclosure Act. This is one of the newer provisions, newer pieces of legislation. It was brought about by the use of DNA testing of workers to find out what their medical propensities are that might lead to discrimination against them. Equal Pay Act. This was the first protection for women, specifically for women. In 1963, it amended the Fair Labor Standards Act. Keep in mind this was before the Civil Rights Act of 1964. And the Equal Pay Act requires an employer to pay men and women the same wage for the same work. Equal pay for equal work. That means substantially the same work. Talk about equal pay in sex discrimination later. The Equal Pay Act does not cover other protected classes, race, color, national origin. That protection would be under the Civil Rights Act, 1964, Title VII. The Pregnancy Discrimination Act protects pregnant workers from discrimination. It also prevents discrimination in the employment. You cannot refuse to hire a pregnant woman. You can't refuse to hire a woman who may choose or not choose to become pregnant. You cannot treat them differently. More on that in the sex discrimination lecture. The Affordable Care Act, we probably talked enough about it. This is a substantial piece of legislation in the employment setting. As far as the health insurance requirement kicking in at 50 or more employees, they are required to have coverage, and that coverage would be for workers working 30 hours or more. This is why there was push toward hiring part-time workers rather than full-time workers. The Affordable Care Act is so broad that it also federalizes breastfeeding in the workplace. The breastfeeding provision of the Affordable Care Act is very similar to Tennessee's breastfeeding in the workplace provision. It does not give the mother who is breastfeeding the right to bring her child to the employment setting, but it does give her a right to have reasonable time off to express breast milk. And with an encouragement of providing the necessary facilities for that, i.e., not go down to a restroom stall to express milk. A little bit more on that later on. The Older Workers Benefit Protection Act. This is an amendment to the Age Discrimination in Employment Act. It covers workers 40 years of age or older, and this deals with usually severance packages when older employees are terminated. Typically what you have when you have a downsizing within the company, workers are targeted for termination, and sometimes they're given a severance package. And with that severance package, there's always a requirement to sign a severance agreement, and that severance agreement contains a provision that says the person, the employee, agrees that he or she will waive any right to sue the employer, and under any provision of discrimination or breach of contract or employment at will or whatever. In essence, if you want this money, you're going to have to agree that you're not going to sue me for age discrimination. The Older Workers Benefit Protection Act does a couple of things. One is it requires employers to give some advance notice of the layoff and the severance. And two, it gives a 7-day right of rescission after the employee the older employee, has signed the severance agreement, for a period of 7 days, that employee can rescind, undo, take back, give the money back, and then maintain all of the rights. Why is this significant? Because the worker is going to sign the agreement, because it gets down to, you're going to sign this because if you don't sign it, we're going to terminate you anyway, and we're going to keep the check. So what this does is it gives the terminated worker the time to inquire to see whether or not there has been any discrimination based on age. Immigration Reform and Control Act, 1986. This was, for the most part, a fiasco in effect. It had good intentions. It just wasn't effective at all. At that time, in 1986, we were dealing with 5 million undocumented workers. If you want to call them illegal aliens, they are. Technically, that's true. And then afterwards, in the 20 years thereafter, 30 years thereafter, nearly 30 years thereafter, now we've gone to another 10 or 11 million. It certainly just did not work. Immigration Reform and Control Act requires that employers obtain proof of the right to work. And this is usually requires the employer to look at 2 pieces of documentation: Social Security card, driver's license, birth certificate, visa, passport, something of this nature. They don't keep it. They don't keep the documentation. Probably a better law would have been to do it, but privacy would have been a problem. And the second thing, it prohibits discrimination against workers based on immigration status. You cannot refuse to terminate or refuse to hire a worker who is authorized to work in this country simply because you don't want to hire any immigrants, or you don't want to take any chance of hiring an illegal immigrant. And secondly, you must not discriminate against them in terms of pay. An employer cannot pay an undocumented worker less than he pays a documented worker or a U.S. citizen. You cannot pay an individual, a worker, less money because it's a legal immigrant versus a U.S. citizen. Obviously, it makes Immigration Reform and Control Act makes it unlawful, civilly and criminally, to hire the illegal aliens or undocumented workers. The Worker Adjustment Retraining Notification Act, WARN, a 1989 piece of legislation that applies to workers, employers of 100 or more employees. It requires an advance written notice of 60 days if the employer is going to lay off, i.e. terminate, 50 or more employees at a facility. If the employer fails to give the advance 60-day written notice, then the employer is responsible for wages for that notice period and also for any benefits. And the benefits obviously could be the substantial part. There are exceptions for insolvency and business exigency where the business simply could not give the notice. Federal Drug-Free Workplace Act, they typically have the state equivalents of those. This is a policy of the federal government and of course the states as well, who have similar provisions. The policy where it is the policy of the federal government to encourage the use of drug testing, to reduce drug usage in the United States, to reduce drug abuse. There are the significant benefit of the Federal Drug-Free Workplace Act is that if an employer qualifies, he has a drug testing program that satisfies the act, then any workers' compensation incidents, any injuries to workers on the job that are caused by intoxication or drug use of the employee, prohibits that employee from getting workers' compensation benefits. It's obviously one that's pushed by workers' compensation insurance providers. Now, what the Federal Drug-Free Workplace Act does, it requires compliance with the Act. And that compliance says there must be a testing for false positive on the drug test. There must the employer may not turn the abusing employee over to the police for prosecution. The employer must give the employee an opportunity to enter into some kind of a rehab program at the employee's expense. And those are the big provisions. It generally allows for pre-employment testing, cause-based testing, and suspicionless testing. And if that's done, there will be, can be no, if there's compliance with the Act, there can be no suits for invasion of privacy, suits for defamation, suits for battery, for taking the blood, and all of that. It gives legal protection on the two grounds. OSHA, the Occupational Safety and Health Act, this provides, this old piece of federal legislation protects the health and the safety of workers. Health is has become more important in the workplace. I would say that OSHA was one of these pieces of federal legislation that led to a substantial demise in labor unions. Historically, labor unions were concerned about the safety of workers. With the federal legislation, the labor unions have less input or less assistance of workers in this area. Another piece of 1980s legislation, 1988, I think, is the Employee Polygraph Protection Act. The Employee Polygraph Protection Act makes it unlawful for an employer to require an employee to take a polygraph test, or to require them to take a polygraph test, or to really even suggest that they have to take a polygraph test as a condition of employment and after employment. I was told by a student at the University of Southern Indiana once, and this student was working for the Dollar General store, that Dollar General's policy back then in the 1980s, before this act, was that employees would take a polygraph test in order to come to work, and then people who worked with money and the inventory would have to take polygraph tests every 6 months thereafter. Well, this would prohibit that. The Employee Polygraph Protection Act has some exceptions, however. One, if it's in the security industry or the defense industry, then such employers can require polygraph tests. And two, if the employer has probable cause to believe that the employee has committed a crime against it, it can require the employee to undergo a polygraph test. The Electronic Communications Privacy Act is one we've already talked about in torts, and we don't need to expand on that provision. Let's look at the Civil Rights Act of 1964. Now, the cases that were assigned to the students cover some of these areas, so we don't have to go into as much depth. So we'll just generally talk about it. I would like to mention that the various states also have similar provisions to Civil Rights Act 1964 and other pieces of federal legislation like Age Discrimination and Employment Act and Americans with Disabilities Act. Tennessee, for example, and they may very well go much broader than the federal legislation, and certainly do 21 states do that for protection of gays and lesbians. Tennessee, for example, for a long time has had a piece of legislation called the Human Rights Act, the Tennessee Human Rights Act. And it covers workers, it covers employers with 8 or more employees. So we're talking about getting down into mom and pop type operations. And if it's unlawful generally at the federal level, then it's also, the employment action is also unlawful at the state action under Tennessee Human Rights Act. And there are more, over the years, there are more lawsuits in this area than there were. It's kind of growing. Title VII. We usually just refer to this as Title VII. Race, color, sex meaning gender, national origin, and religion. An employer of 15 or more employees are covered. Now, you don't count a partner or an LLC member as employees. Now, corporation, you would count a shareholder who was also the CEO as an employee. The claims under Title VII can be based on two notions: disparate treatment or disparate impact. A claim based on disparate treatment requires a proof of intent to discriminate. A claim based on disparate impact is a claim that's based on statistics. Looking at the facts and circumstances and the numbers, it's statistics. Statistically, you are discriminating because you have not employed enough African Americans, or you haven't employed enough women, or you haven't employed enough minorities. Given the available employees out there who could work for your firm, you are hiring substantially less, and that substantially is 80%. If you fall below 80% employment of the available workers, minority workers, women workers, whatever you're looking at, if you fall below that 80%, and this is called the 80% rule, the EEOC's 80% rule, then the EEOC may look at it. Usually, if you're at 80% or over 80% hiring, then the EEOC will leave you alone. Title VII covers employees of American companies overseas and covers resident aliens in the U.S. who are hired in the U.S. Keep in mind, a resident alien is one who is authorized to work in the U.S. All right? They have a work card, they have a work permit, the green card, if you will. They are under certain type of visas, right? The H-1B visa is most commonly talked about, an L-2 visa or something of this nature. You have a right to work in this country, which separates you from illegal aliens or undocumented workers. Then you're protected under, these persons are protected under Title VII. Last topic that we're going to talk about in this lecture is the Americans with Disabilities Act. Title I of the ADA. The threshold is 15 or more employees. As I said before, it covers employees with disabilities. Before there was the Americans with Disabilities Act, there was 1970s piece of legislation, the Federal Vocational Rehabilitation Act, and the commonly called the Vocational Rehabilitation Act. And this provision required that the federal government not discriminate against persons with disabilities in employment and in federal contracting. It also includes, similar to the ADA, prohibition against discriminating against persons who receive federal money. You know, you couldn't discriminate because of disability in any government contracting or government grants, or if for example, any university where students receive federal, where the university receives federal financial assistance, you couldn't discriminate. So now most of the legislation is in the ADA. This was 1989 piece of legislation signed by President George Herbert Walker Bush. It was an easy piece of legislation to sign. It has proven to be a very broad piece of legislation, an uncontrollable or unmanageable piece of legislation, but all based on good intentions. Because back then, 25% of the people either had a disability or knew someone that had a disability. So it was a substantial number of the population. A disability is a physical or mental impairment that substantially limits one or more major life activities of such individual. Now, it was a few years back, it was amended, and we'll talk about what those are with the ADA amendments. Disabled persons with disability, the physical or mental impairment, applies, and the ADA applies and gives protection to those workers if that worker has a disability, had a disability, or is regarded as having a disability. Is regarded as having a disability means the employee was never disabled, but the employer treats the employee as if he or she has a disability. Had a disability. At one time the employee was disabled but got over it. Key provision of the Americans with Disabilities Act, other than the prohibition against the discrimination in hiring, firing, transferring, demoting, work assignments, transfers, etc., is that the employer must make a reasonable accommodation to the disabled employee. The two areas that requires reasonable accommodation is under Title VII, religion. A religion must be reasonably accommodated, and a disability must be reasonably accommodated. Now, there is no requirement to make a reasonable accommodation that would cause an undue hardship to the employer. There's your limitation, the undue hardship limitation. Similar to Title VII in religion, although what is a hardship for an employer as a disability is much more stringent than in religion. In religion, it's an undue hardship to accommodate an employee's religion if it would cause anything more than a minimal hardship. Hardship for ADA purposes is a real hardship. There is no coverage under the ADA, at least for the time being. I think we're probably going to see some changes made, certainly at the state level, for sex-based conditions such as transvestism or gender identity disorder. Now, what you may very well have is for federal contractors, the gender identity disorder probably is going to apply, but for employers not. There will be some states that will give the protection. Second, psychological criminal conditions such as kleptomania or pyromania. These are not desirables within the workplace. And then the current use of illegal drugs. Now, note that an individual who is a drug addict because of past use, clean right now, but past use, that person is covered by the ADA. Same with an alcoholic. You never recover from alcoholism. Well, as long as you're clean right now, you're covered. But once you fall off the wagon and you become a current user of illegal drugs or alcohol, then you're not covered. You're not disabled. In the 1990s and the first decade of the 2000s, the Supreme Court heard some cases, and they in essence put the brakes on the ever-expanding Americans with Disabilities Act. The courts were expanding what was a disability wider and wider and wider, broad and broad. And the Supreme Court heard a few cases, 3 in particular cases, in which they limited the coverage of the ADA to bring it down into what congressional intent was. And this had to do with what was a disability and what was not, and mitigation. These Sutton versus United Airlines dealt with the mitigation provision, or dealt with disability and work. And then there was one dealing with mitigation for medicine taken, and then Toyota Motor Manufacturing versus Williams, which kind of worked as the last straw for Congress. The ADA Amendments Act was one of the first pieces of legislation when Barack Obama became president. He had good control of the House and the Senate, and they undid a lot of the they broadened the ADA's coverage. They said under the Amendments Act that a broad scope of protection for employees, and it instructs the courts to provide the coverage for plaintiffs to the maximum extent permitted by the statute. There's an old legal maxim that's commonly applied in workers' compensation and unemployment compensation cases. And this legal maximum is remedial statutes are to be construed liberally. Remedial statutes are to be construed liberally, meaning if the plaintiff is given some kind of a benefit to make them whole under a statute, then the tie goes to them, because you'll have a liberal application of it. You don't construe it narrowly. Let me just give you very quickly Sutton and Toyota, if I recall them correctly. Sutton versus United Airlines. Mrs. Sutton was one of two sisters working for United Airlines. Now, she was monocular. She could see out of one eye, and nearsighted, farsighted type thing, if I remember correctly. And United Airlines had this requirement under the FAA as to what the eyesight requirements in order to fly the big planes. Now, smaller planes have a lesser eyesight requirement than the large planes. Miss Sutton, the plaintiff, wanted to fly the big planes, and they told her, you can't fly the big plane because of your visual condition. And she says, no, I want to apply, and I'm disabled. Right, my monocular vision is a physical impact, is a physical impairment that limits one or more major life activities, and that one or more major life activities means flying these big planes. And the Supreme Court says, no, you're not disabled. The ADA does not guarantee you the right to do, because of a disability, to do this type of work. The fact that she could see well enough and had vision well enough to fly the lesser planes meant that she wasn't disabled. The other case I was telling you about mitigation is, if the doctrine of mitigation, as here, a disability can be mitigated if you can correct them. You can correct the disability by wearing such things as eyeglasses or contact lenses or sight impairment and things of this thing, or taking medicine like epileptic seizures. In the Toyota Motor Manufacturing versus Williams case, this is a case in which Mrs. Williams, an employee of Toyota, had been working in warehouse, in distribution for Toyota, and her job of working in the warehouse required her to bend and stoop and lift and stretch and all of this. And she developed an injury to her back, such that she couldn't do all these things. Toyota put her in a sedentary position for a while to help her heal, and kept her there for months. And then, she could take care of herself personally, but she did not have the physical ability to do all the stooping and the stretching and all that. So Toyota finally told her, look, if you can't do your old job, then we have to let you go. Your job requires you to be able to do these things, and if you can't do these things, then you're not. We can't afford to pay you. She says, I'm disabled. I have a physical impairment that limits one or more major life activities. And this limits the ability to work. And the court said because she could take care of her personal hygiene, her personal safety, she could brush her teeth. She had movement in her arms to brush her teeth and to take a shower and to towel off and to walk here and to walk there to take care of herself personally, then she was not disabled. And she was not covered under the Americans with Disabilities Act. She lost. All right, let's look to see how the ADA has masticized. Disability has been liberalized under the ADA Amendments Act. It does not mean unable to perform or significantly restricted. Or does not mean to prevent or severely restrict. Which was Toyota manufacturing. It lowers the requirements as a matter of policy. In essence, it allows for more lawsuits. Major life activity include, but are not limited to, caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, that could be a big problem, thinking, communicating, and working. You see the breadth of this? If there's anything wrong with an individual, that individual may be disabled under the ADA. It includes major bodily functions, including but not limited to the functions of the immune system, normal cell growth, digestive system, bowel, bladder, uncontrolled, irritable bowel syndrome, I suppose. The bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. An impaired major life activity need not limit another major life activity. So we have broadened this thing out. So what about unable to perform sexually if that causes you psychological problems? Might that be covered? Seeing at night. Older workers have problems seeing at night. Heavy lifting or using a computer. See the breadth in all of that. All right, this ends this first lecture on employment law. The next one that we will deal with will be labor law, and then I will try to have one put up for sex discrimination.